Are you receiving a settlement and wondering if you'll have to pay taxes on it? Are you ready to receive a settlement, but you're worried about the tax hit? Well, you're in the right place. These are common questions for plaintiffs who are navigating the settlement process. You're hoping to finally get money from your lawsuit, but you're worried about how much the IRS will take. Well, the truth is that settlement taxation is complex. Some types of settlements are completely tax-free, while others get hit hard with taxes. And there are some major pitfalls to watch out for. So today, in this comprehensive overview, I'll share 7 tips and pointers for figuring out if your settlement is taxable. And if your settlement is taxable, make sure to stick around until the end, where I outline some of the best tax-saving strategies. So I'm Greg Maxwell. I'm a settlement planning attorney and a certified financial planner. And I work with plaintiffs all over the country to help them avoid paying too much taxes on their settlements. So before we dive in, just note, the information contained in this video is intended for general informational purposes only and is not intended to be tax advice. All right, let's jump right into the 7 tips and pointers for figuring out if your settlement is taxable. So tip number 1, the default rule is that settlements are taxable. And I have to start with the bad news first. The default rule is that legal settlements are taxable income. The IRS says that all income is taxable from whatever source derived, unless an exception to that taxation applies. So in other words, unless your case falls into an exception that avoids taxation, your settlement will be taxable. And I have more bad news. In 2005, the United States Supreme Court ruled that the amount you, the plaintiff, must pay taxes on is the total gross settlement, including the amount you paid to your attorneys for their legal fees. So for example, if you get $1 million settlement and you pay $400,000 in attorney fees, you'll only actually receive $600,000. But unless an exception applies, the IRS will require you to pay taxes on the full $1 million. This is true even if the defendant paid your attorney directly for his or her fee, and even if money never passed through your hands. So we'll come back to this in tip number 6, but this can be an absolute gut punch to you as a plaintiff. So the starting point should be to assume that your settlement is taxable, and then we look for exceptions and explore tax planning strategies. So tip number 2 is the origin of the claim rule determines taxation. So the origin of the claim rule is used to determine how lawsuit settlements and judgments are taxed. Essentially, the tax treatment depends on what the plaintiff is seeking to recover through their legal claim. So here are some examples. If someone sues for lost business profits, the settlement will be taxed as lost profits, ordinary income. If someone sues for lost unpaid wages, then the settlement will be taxed as wages. If someone sues their employer for discrimination, the settlement would be taxed as ordinary income. In a defamation lawsuit, the settlement is taxed as ordinary income because the origin of the claim was for damage to reputation. So the nature of the original claims made in the case largely determines how the ultimate recovery is taxed, regardless of how the case ends up being resolved. The origin of the claim rule means that plaintiffs and their lawyers need to carefully consider the tax implications when first asserting their claims and throughout the litigation. In short, the settlement compensates you for whatever type of damages you originally claimed, and the settlement gets taxed accordingly. So tip number 3, settlements for personal physical injuries are tax-free. So now for some good news. If your settlement is for a personal physical injury or physical sickness, the settlement is 100% tax-free. So here are some examples of tax-free injury settlement cases. Car crash cases if you had medical bills, injuries like whiplash, etc. Slip and fall cases if you broke a leg or had other injuries. Workplace injury cases if you suffered physical harm. Dog bite cases. Medical malpractice cases for a botched surgery that caused physical damage. It's important to note that this exception only applies to personal physical injuries, injuries to the body. And this exception is actually more limited than you might think. So since 1996, the IRS has ruled that your injury or sickness has to be clearly physical in nature in order to qualify for tax-free treatment. Things like depression, insomnia, headaches, stomach issues from stress, and emotional distress are not considered physical by the IRS. However, illness or injury that causes emotional distress is considered physical and can still qualify for the tax exclusion. So do you see the difference? It's about the sequence of events. So for example, if you undergo a botched surgery and sue for medical malpractice, practice, develop PTSD, and then suffer emotional distress from the PTSD, that whole chain reaction is likely excluded and would be tax-free. But if you're just stressed out from work, develop headaches, and claim emotional distress from those headaches, that's considered a symptom of mental distress. So it's taxable. It's strange but true. The key is your lawsuit must claim damages specifically for physical harm, and you need evidence, like medical bills and treatment, to prove it. So the personal physical injury exception to taxation is one of the most common and most helpful ways to avoid being taxed on a settlement. So tip number 4, medical expenses are tax-free. Another great tip is that medical expenses related to your case are always tax-free. The tax code considers reimbursements for medical costs to be tax-exempt payments, even if the rest of the settlement is taxable income. So this is a great opportunity to work with your attorney to make sure your settlement agreement with the defendant specifically allocates reasonable portion of the settlement to both past and future medical expenses. Spelling out this allocation in the settlement agreement provides you with valuable proof if the IRS ever asks why you didn't pay taxes on that portion of the settlement. So any amount of a settlement that is specifically allocated to past and future medical expenses will avoid taxation, which of course puts more money in your pocket. Tip number 5. Allocating damages can save you on taxes. So in many cases, lawsuits involve multiple types of damages: lost income, medical costs, emotional distress, pain and suffering, and so on. Allocating specific settlement amounts to each type of damage can minimize your tax bill. So as we talked about in tip number 2, how a settlement is taxed depends on the origin of the claim and the nature of the settlement. So for example, if you're involved in an employment lawsuit, your settlement could be made up of several different damage types. A portion of the settlement might be for lost wages, which requires withholding of taxes and reported on a Form W-2. A portion may be for non-wage emotional distress damages, which is taxable, but not as wages. It would be reported to you on a Form 1099. A portion could be for some reimbursed business expenses, usually non-taxable unless the employee had already deducted them. And as we talked about in tip 4, a portion of the settlement could be allocated to past and future medical expenses, which is tax-free. So when feasible, based on your claims and facts, work with your attorney to allocate more of the settlement or as much of the settlement as possible to tax-free or non-wage damages in your settlement agreement. This is perfectly legal and can save you a bunch of money. Tip number 6, many plaintiffs cannot deduct their attorney's fees. And here is where this gets really tricky. Back in point number 1, I mentioned that because of the Supreme Court rulings, plaintiffs must pay tax on the full gross amount of the settlement. So for many years, this didn't harm plaintiffs because they could just deduct the attorney fee portion of the case on their tax return. And so they wouldn't have to pay any taxes on the amount paid to their attorney. However, since the passage of the Tax Cuts and Jobs Act in 2017, many plaintiffs can no longer deduct their attorney's fees at all on their personal tax return. The Tax Cuts and Jobs Act removed the miscellaneous itemized deduction from tax returns, which was the main way in which many plaintiffs deducted their attorney's fees. So this means if you get $1 million gross settlement and you pay your attorney $400,000 in legal fees, you're left with $600,000. But you pay tax on the full $1 million because you cannot deduct what you paid to your attorney. So this means in most cases you have to pay tax on your total recovery, even though up to 40% went right to your attorney. Yikes! The main types of cases where plaintiffs still can deduct attorney's fees are employment discrimination or retaliation lawsuits and whistleblower claims. So in personal injury cases, of course, a deduction isn't needed because the settlement is already tax-free. In nearly every other case type, however, plaintiffs cannot deduct their attorney's fees. So plaintiffs are paying taxes on money paid to the attorney, money they never receive. And this is wildly unfair and likely an unintended consequence of the Tax Cuts and Jobs Act. So this leads me to my final pointer. Tip number 7. Using the Plaintiff Recovery Trust and structured settlement annuities can dramatically reduce the amount of taxes that you ultimately pay. So my firm uses 2 specialized tax planning tools that can drastically minimize your tax bill. The first tool that we use with clients nationwide is the Plaintiff Recovery Trust. This specialized trust allows you to avoid being taxed on legal fees in cases where you cannot deduct legal fees. So again, in point number 6, we talked about how many plaintiffs cannot deduct their attorney's fees. The Plaintiff Recovery Trust is the solution to that problem. And depending on which state you're in, using this tool can often double or triple what you end up keeping after taxes. The second tool we use with clients is called a structured settlement annuity. A structured settlement annuity allows you to receive settlement payments over 2 or more years rather than a lump sum in the year that the case settles. So this effectively spreads out your income, which lowers your overall tax rate, which then reduces the total taxes that you owe over time. So using either one of these tools can greatly increase your after-tax net recovery from your settlement. And by combining these tools, we can often double or triple what you get to keep after taxes. So how would you like to double or triple your recovery? But watch out, because both of these tools need to be set up before your case settles and before the final release agreement is signed. So once the case is settled and the final release agreement has been signed, it's too late. So if you're in the middle of a lawsuit and you're worried about taxes, please reach out to my firm now so we can do some proactive planning. Once your case settles, once the release agreement is signed, there's really not much we can do to help you. So don't wait. So there you have it. Those are the 7 essential tips and pointers that you need to know to figure out if your settlement is taxable. So let's just quickly recap what we've learned. So tip number 1 is that the default rule is that settlements are taxable. Tip number 2, the origin of the claim rule determines taxation. Tip number 3, settlements for personal physical injuries are tax-free. Tip number 4, medical expenses are also tax-free. Tip number 5, allocating damages can help you save taxes. Tip number 6, many plaintiffs cannot deduct their attorney's fees. And tip number 7, and most importantly, using the Plaintiff Recovery Trust and structured settlement annuities can dramatically reduce the amount of taxes that you pay on your settlement. So taxation of settlements is complex, but you can avoid paying taxes on some or all of your settlement money with some strategic planning. So if you're getting a legal settlement and you're worried about taxes, we're here to help you. We offer a free, no-hassle 15-minute phone call for settling plaintiffs nationwide. You can find a link to book a call in the description or comments next to this video. Or you can go to amicusplanners.com/call to book your call today. If we determine on the call that you will have to pay taxes on your settlement, my firm will prepare a customized, no-cost tax savings analysis for you, showing how much money you can save with the tax strategies I shared today. So in the meantime, check out our proprietary settlement tax calculator at settlementtaxcalculator.com. The calculator will estimate how much you'll have to pay in taxes, and it shows you how much more money you can keep by using one or more of the strategies we mentioned in this video. But please don't wait to reach out, since all of the tax planning strategies I mentioned today have to be set up before you sign the final release agreement, before final settlement. So it pains me when someone pays way too much in taxes because they didn't know or didn't do the planning before settlement. So thank you so much for watching, and I look forward to speaking with you soon.